Simon, can you hear me?
Yes.
I'm going to mute everyone, so please unmute yourself after I mute everyone.
Okay, thank you.
You can unmute now, Simon.
Okay. Tessie, can you hear me on Zoom?
Yes.
Yes.
They're all muted. They're all muted. Move your hands. Move your hands.
All right, just want to make sure you can hear me okay.
Raise your hands.
Blink twice.
That's
Blink twice.
Wow, look at all these people jumping on Zoom, so it must be a hot topic, right? Super hot topic. All right, well, I appreciate you all. We got about 50 people jumping on Zoom, so thank you very much. Yes, big changes going on with the with zip forms, MLS, and all the craziness that's happening and has happened in the last couple of days. So I appreciate you all. My name is Simon Cazares, team leader and broker for the South Bay Torrance office and also the Long Beach Coastal office. So I thank you so much and I appreciate you. Yes, thank you. I hope trip. So we're going to go in really deep into the new listing agreement. All right. Wednesday, the 24th, we had the significant changes where the old listing agreement is completely removed. Now they transition into the new revised listing agreement that we're going to dive really deep into the conversation. Okay, we're going to dissect it and we're going to go into a lot of the questions and concerns that all of you have as well. All right, so for the time being and for the sake of time, I know this is probably going to go more than an hour, but I want to be able to just go through the surface of the listing agreement before we go into actual questions. So I want you to please write notes, and then I'll give it some time for you guys to ask me questions after. Because if we get too many interruptions, then there's going to be something that I'm going to miss, okay? So for the sake of time, I just want to make sure that all of you have the opportunity to address any questions you have regarding the form. All right, so I'm not going to go into it, but now the new form from its original 5 pages is now 7 pages long. Okay, so fun times for sure. There's a lot of verbiage around commission and concessions, commissions, and how all that's going to work with the new form. The old form had a section on the first page of the listing agreement that allowed the total commission plus any cooperating compensation to anyone that brings you a ready, willing, and able buyer. The new listing agreement has completely deleted that section. Okay. So, as most of you are aware, the agency regarding relationship is still the same. Okay, nothing has changed on the AD form. Okay, I've already added the language on here for the sake of promoting and educating you on the new form. So I'm going to bypass the agency form and we're going to go right into the listing agreement. Okay. So if this is the first time seeing the listing agreement, they've added, similar to the purchase agreement, a grid. Okay, a grid. What I like about the grid, it really defines on finding the answers to all of your questions and how you're going to navigate the conversations moving forward with your sellers. All right, it's pretty self-explanatory. But let's dive into it. The new listing agreement, revised, and make sure it says 7/24. Okay, that's the most current listing agreement that we have. Data preparation. Okay, I put today's date on preparing this form. This is an exclusive right to sell, and it says very top, exclusive, authorized, and right to sell. Okay, that means that anyone brings a buyer, offer gets accepted, you close the deal, you still earn a commission. That's what an exclusive right to sell. Okay? First section is the seller's information. Okay, Mr. and Mrs. Smith, who has employed, this is where you're going to put the brokerage, okay? Okay, the brokerage, Keller Williams Realty South Bay, as an example, right? If it's coastal or any of the other office. Has the right to sell and exchange real property. This is where you're going to put the address of the subject property. I use it as an example, 123 ABC Street, City of Torrance, Los Angeles County, 90505. So far, we good? Okay, good. Okay. On the zip code follows is the assessor's parcel, right? You always want to make sure that you do have a parcel number. I'm just going to use this as an example. Let's see, it's not going to allow me to add that. Okay, you're going to put the APN number on the parcel. Now we're going into section 2 of the listing agreement. It goes into 2A, 2B, 2C. Okay, 2A is the listing period. The listing period. The beginning date and the expiration date will end on, as an example, and this is, let's just go. Okay, December 30th, 2024. Okay. At 11:59 p.m., this listing, if it hasn't sold, would become a what? An expired listing. That's correct. Now they added additional language to paragraph 2A1, and that's the maximum length. Maximum length. And the provision says that it's not to exceed 24 months if approved with 1 up to 4 units. So if you represent a seller, okay, the maximum amount that you can on this listing agreement is 2 years. But it also has a provision in there that says the following. If the property falls under a corporation, LLC, or a partnership, then there is no maximum length of time. Okay.
So if the owner is.
If the owner is a corporation, if the owner is an LLC, S Corp, C Corp, or a partnership, then it's not a provision of the 24 months. Okay. Now, what's your typical listing period?
6 months.
Typically, it's
6
about 6 months.
A year.
Correct. Yeah, 6 months to 1 year is typical, but they've added this additional language to the form. Okay. Now I used on section 2A2 listing price. I just used as an example. This is the listing that we're going to market it at $1,050,000. Section B goes into property specific listing. If the property is a manufactured home, or if it's a probate, conservatorship, guardianship, then you would check that specific box and then it will populate the additional forms. Okay. Section C. Hey, this is where it gets exciting. This is where the fun of this new listing agreement comes into play. Compensation. Noted, the amount of rate of real estate commission is not fixed by law. Okay. This was on the past form, and this is on the current form as well. Okay. But they also added a new form called the BCA form. Okay. Broker Compensation Advisory. All right. Now, when we scroll down, now we're going into the compensation of services rendered for helping a seller sell their home. C1, C2, C3, C4 goes into the illustrations of what you can get paid for. It doesn't have anything on there that talks about buyer commissions. Okay? All that it has is seller's information. C1, okay, talks about compensation to the seller, broker, only seller side of transaction. This is what you are going to charge the seller for helping the seller sell their home. And whatever that amount is, okay? I use 3%. Now, do you also see these boxes here where it says 4B, 4C, 4D2? Those are the paragraphs that you can go now and get the answer to that specific grid. So if I wanted to get a little bit more understanding of what C1, I just need to go to 4B, and then it'll tell me a little bit more information of what that provision means. Okay? Now you can also add additional fees, if any, under this blank section. Or you can ask for a flat fee. Instead of a percentage, you can say, I'll take $25,000. Okay? That's the options. Section C2, if checked, is compensation to seller's broker if buyer is unrepresented. Unrepresented. What that means is if a buyer does not have an agent representation with another agent, that is considered an unrepresented buyer. Therefore, full transparency, folks, you can ask the seller if that situation occurs, can I get compensated? Doesn't talk about the buyer's agent, it only talks about you as the listing agent. Okay, I put 2.5%. If I'm hosting an open house, buyer comes in, we go through the motions, and they say they are not working with any agent, they don't have a buyer representation agreement in place, but they do want to submit an offer on this particular property. And that offer is accepted, and we close, the seller will pay an additional commission.
Do you have to have them sign a buyer's broker's agreement before you take the?
100%. Yeah.
Okay. Before you take the offer?
Yeah. I'll explain how you're going to maneuver the buyer representation agreement and the listing agreement as a combined. Because I know there's going to be a lot of questions regarding, well, why would I need a buyer representation agreement if the buyer is already buying this property? Because we still need to have a conversation with the buyer regarding any real estate conversations to make sure you're in compliance with NAR.
And the 2.5% is an additional to your 3%.
That is correct.
So that's a 5.5% actual listing in reality, if you represent both buyer and seller.
That's correct. Yes. So this is not subtracting from the 3%. This is a total 3%, 2.5%, 5.5% as an example. That's only if you are working with the buyer in submission of an offer. Okay. If there's any additional fees, you can put it here in this section, or you can also ask the seller for a flat fee. A percentage or a flat fee. Okay. You can also check attached compensation schedule. Okay. That's if you want to include like a breakdown. If you get a certain tier, this is what we're going to charge. Anything above, this is what we're going to charge. Then you can add that compensation schedule. C3. Okay. C3 is no different than with the current, the past listing agreement. It's continuous right of compensation for broker, broker identified prospecting buyers. So this is a provision, again, if the listing gets expired or canceled during that time frame of 5, 6 months or a year, that if you provide the seller with a list of anyone that has seen, submitted, or was broker involvement, and that buyer, after it expires or cancels, comes back and buys the property, you as the previous agent are entitled to compensation,
That's fair.
okay? You always want to put something. Always put something, whatever that amount is. Do not leave it blank. But there is homework you have to do in order. Just because you add a number doesn't necessarily mean that you're entitled to a commission. You have to do a couple steps, okay? Just before it expires or just before it gets canceled, make sure to provide the seller with a list of all of the buyers who have submitted an offer, seen the property. You have registered on an open house. If any of these buyers come back to buy, then you're entitled to a commission. And I'll explain, one second, and I'll explain how that works. If you are now on the back end of it, getting an expired listing and how that's gonna work. If a seller says, well, look, I'm willing to list the property with you, right? But in order for me to do so, I don't want to pay double commission. Okay, I have a list from my previous agent. If any of these buyers buy, then I'm not responsible to pay you a commission. Make sense? Any questions?
Are
Okay.
they gonna qualify that as a different type of listing? Because that is like an exclusive listing, then, am I correct? Because it's not exclusive right to sell. Because exclusive right to sell states in the real estate book, because I know I've just taken 3 tests, that anybody who brings an offer with an exclusive right to sell, the seller has to pay you a commission. So that would
Yes,
be,
but this
I think
is-
it's gonna revert over to an exclusive listing instead of. exclusive
I
right.
think you're a little confused. This is if it expires or cancels.
Oh,
Not during, because, yeah, during,
Alright.
even if the seller brings a buyer, you're still entitled to a
okay,
commission.
if it expires, okay,
Yes.
that's.
Expires or cancel the listing, you provide this list, then this provision will be in full effect, okay? So this is extra timeframe if that buyer comes in and submits an offer, gets their offer accepted. Rosie,
Yes, what happens if the seller choose to pay the buyer's agent a commission? Where does it go? It says, see attached compensation schedule. Is that what we are gonna have an additional form?
I'm sorry, what was the question again, Rosie?
If the seller choose to pay the buyer's agent commission, where do we see that?
Separate negotiation.
Well, it's going to be a separate agreement. Is this, you mean after the listing expires or cancels? Is that
No,
what?
no. You have a listing, you talk to the seller, and the seller says, you know what, I would like to pay some commission to the buyer's agent. Where do we put that?
Okay, so there is no provision on that. And I would encourage you not to be having those conversations because there's nothing on here right as we speak on this listing agreement, Rosie, that says about compensation. Remember, August 17th, ladies and gentlemen, August 17th is going to be the due date. That's where CRMLS is going to remove the compensation, the BAC on the MLS. It's going to eliminate it from the MLS, okay? Now, we're going to add an additional conversation, Rosie, because from now till then, we have what's considered a gap, okay? And that gap is, well, it hasn't fully been effective till next month, right? So what do we do for those situations where the seller is still wanting to pay a compensation, okay? And that compensation is an additional called the gap addendum. There was an email sent out to all of the offices. If you're going to have that conversation with the seller, then that gap addendum will be part of the listing agreement. It's a supplement to the listing agreement. Okay. Now, I just saw on CRMLS that I believe it was August 13th. I think there was a change. Don't quote me, but I think August 13, there's gonna be some changes. I think that's gonna be the day where we're gonna see the compensation be removed from the MLS, okay? I'm not 100%, I kind of glanced on it, and then I stepped into the training room, okay?
Another question.
Yes,
So if I thought that I had the answer, but if we have a listing already in the MLS, but had not been closed by August 17, and the seller has already agreed to pay a commission, is that gonna be okay?
yes. To answer your question, if you have an existing listing agreement as we speak right now, right? Leave it alone, stays the same. The seller has already agreed to the terms of that listing agreement, so whatever compensation is to paying a cooperating broker stays the same. You're all with me. As soon as August 17, and that's subject to change, then we're gonna include what's called a supplemental form to the existing listing agreement. It's a modification of the listing. And what that form entails is information about the NAR settlement and that MLS, CAR, NAR have eliminated concessions to any cooperating broker. Meaning that the seller doesn't have to pay concessions or commissions to the buyer.
So now whatever is on the MLS gets wiped out.
That is correct. Yeah, because once that commission is removed, what was 2.5%, 2% is not gonna show any. So that modification of terms form will need to be signed by the seller. The seller needs to understand that these are the new changes by law that we need to be part of. Okay. Now, what does that mean? Well, we're gonna go into it later, okay? So let me continue back to the actual new listing agreement.
Hey,
Okay?
Simon, before you move, can I ask a question on C2?
Yes,
What if the buyer is an agent? Does the seller's broker still qualify for section 3 C2?
yes. So that section stipulates and anyone that's unrepresented. So this means that if you're the listing agent, right? But you're
Yeah.
also under C2, get a unrepresentative buyer that doesn't have an agent, okay? That's you as the listing agent. Then you're
But-
entitled to commission.
But they're an agent themselves. They're representing themselves. Do we call them unrepresented?
As long as they're representing themselves with no agent, I understand if they're a licensed agent, but if they're a licensed agent, then they're not considered, if they're gonna submit an offer on behalf of themselves, then no, that's not considered an unrepresented. This is only someone that is not working, does not have a buyer representation agreement. Let's just say you're an agent, right? I don't want to represent myself. I'm licensed, but I want you to represent, then yes, you're still entitled to a compensation.
She's talking about if you just walk in and say, I'm a broker and I normally get paid, so. Because he's actually representing himself, so.
So if they're representing themselves, then no. This
So
is,
they got to negotiate their commission if they expect to get a commission.
this is only, folks, I just want to be clear that this is only if the buyer comes in, I have no agent, I have no buyer representation agreement. I want you as the listing agent to submit an offer on my behalf. If they're licensed, that's great, okay, no problem, but they don't want to be represented themselves, they want you to still represent, you're entitled to compensation if you put in check C2. Hope that kind of answers your question.
500 bucks.
Okay,
I know they're confused.
there's gonna be a lot of questions, and I completely understand. I completely understand. All right, C4 goes into seller obligation to pay previous broker. Okay, this is, again, if you're going for a listing presentation, but it might have been an expired, right? It might have been an expired listing, then C4 goes into, did the seller have a previous agent or was it previously listed? Then you're gonna put the name of the broker and compensation above broker, or if the property may be transferred, right? So if the seller says, yeah, I have the property listed with ABC Realty, okay, that's telling you, hey, there may be a list that the seller may have. So we need to make sure that we know how to maneuver and navigate the conversation, right? Because you may put all the time, effort, and energy, and a previous buyer comes in, submits an offer, you may not be entitled to compensation. You all with me? Okay. Now we're going into D, items intended to be included or excluded. Pretty self-explanatory, right? If items included, you check and you add. Okay. Item D2, items excluded, okay, whatever that is. If you're having a conversation, Mr. Mrs. Seller, what are things that are going to stay with the property? Full transparency, so you know and the seller knows, so there is no misunderstanding. I've seen situations when there's no communication, what someone believes is going to stay doesn't stay, and now the buyer says, well, what happened to that? I thought that was part of the agreement. How do you reinforce it? Obviously, putting it on the MLS too. What is staying, what is not staying? Okay. If the seller knows they're going to replace something, they should replace it before the property goes on the market. Absolutely. Okay. That way, the buyer does not believe that something is staying with the property. Y'all with me? Okay. Or make it very clear to the buyer agent and also the buyer, as during the due diligence period, disclosure period, that you're telling that specific agent and buyer, this is staying, this is not staying. Okay. And make it clear, make it very clear on the listing agreement too, so you don't forget what is staying and what is not. Because I've seen scenarios and situations where agents also fail to know what's staying and what's not, and before you know it, it may be too late, and now you're compromising the transaction, or now someone is paying additional fees. Okay. D3, D4 go into if the property has any leased items, okay, or any liens against the property, okay. If it does, then you check off. D3, solar panels, water softeners, alarm systems, propane tanks, high desert usually have propanes. Anything that's liened, okay, if there's liens attached to the property, like the HERO program. How many have heard of the HERO program, right? People believe they get these items for free. But in essence, they don't. Okay, you're paying it some way or another. So make sure to let title know, because title will know if there is anything that's tied to the property that is now part of paying it off. Make sense? Any questions regarding leases and liens? Okay. Let's see, what do we have on the chat? Nat, are you still on what if a buyer is an agent buying for himself? Yeah. No. Yeah, so no, that would not consider. All right, D5 goes into if there's any specific smart home features, right? Like a Ring camera, surveillance cameras, stuff of that nature. What is included, what is not included, you're going to put it under D5. Okay. Now we go into the MLS and marketing. E1 goes into property will be marketed in the following MLS. Okay. Most of us, our primary is CRMLS, right? And it gets syndicated to other third-party sites as well. But let's say you syndicate it to a specific one as well, then you can add additional under other. Okay. E2 goes into seller instructs broker not to take or use photography in marketing except as required by the MLS. Okay, what does that mean? Well, it means if you check it, the seller is instructing you, I don't want any photos.
Just the
taken of
photo of the
property.
front. Required by the MLS.
If you're going to put it on the MLS, part of MLS rules and regulations, you must have at least one exterior photo of the property. Okay, and that's it. Then you're in compliance with the MLS and you're in compliance with your seller's instructions.
Next page.
All right, any questions regarding the first page of the listing agreement?
6 more pages to go.
All right. Now we're going in page 2, timing of presentation of offers. F1, seller instructs broker to present all offers received as soon as practical. What does practical mean?
As soon as you receive it.
As soon as you receive it, yeah. As soon as possible.
If
But it
you-
also has-
You got to call your seller and wake him up.
That's why it says practical.
Right, exactly.
And 10 o'clock is not practical if you're asleep, right? So practical. So if check, what you're telling the seller is that, listen, I don't want to receive offers as they're coming. If you check, then we're going to give it 10 days after it goes active. Then you can present all offers, or you can put a specific date.
This is very good. I like this because now it specifies, because other agents accuse you of doing, holding back their offers or doing something. Now you have it actually written down in the listing agreement and you have proof of everything. And for the broker I'm talking about, you know.
100%, 100%. Okay, so clear, consistent, full transparent. This is your value proposition. When you're sitting down with the sellers and going through the motions of the listing agreement, you want to know exactly how you're presenting and the reason that you are the agent of choice, right? So any questions regarding F1?
That tends to be a new standard, right? It's like a lot of offers will be made and say, I need to get an answer in 3 days. So it's 10 days.
Well, if it states here that the seller does not want to receive offers, then we're going to put on agent remarks, right?
Hmm.
What's the language? That all offers to be
Review in 10 days.
received or reviewed 5, 7, 10 days, whatever that.
So you don't have to present your offer or you date your offer. You have to.
Because how many times does an agent call, hey, is my offer going to be presented immediately, right?
Mhm.
Well, this provision allows you to say, no, unfortunately, all offers are due no later than Friday of next week, right?
Now you can't get in trouble if they say present as soon as possible and you hold back the offers too. Am I correct?
100%.
But that's not a new standard, 10 days. That's not what you're saying, right?
No.
No, it's not.
So, okay.
That's why it's an empty box.
Yeah.
F2 goes into buyer supplemental offer letters, okay? Seller instructs broker not to present buyer letters, okay? So if you don't check it, what the seller's telling you is that they do not want these, consider these love letters, okay, as part of the package. Typically what we see is the full purchase agreement, pre-approval letter, proof of funds, and sometimes buyers will submit their letters, right? This section says about presenting buyer letters. If seller requests or relies on buyer letters, seller is acting against broker's advice. Okay,
Wow.
that's also, I believe, on the previous listing agreement too as well. F3 goes into investigations. Important and pretty vital here, all right? This is where your engagement and your value proposition that you're ahead of the game is Mr. and Mrs. Seller. Part of the process in helping you sell your home is you can get independent investigations to know what the issue is with your property, okay? It already defaults the natural hazard disclosure. You can include a termite inspection to be done, a general property inspection, homeowners association documentation, preliminary title report, roof, pool, etc. Okay. What this is basically before the property even goes on the market, you've already done some due diligence, and now you have some inspection reports that now you can use as negotiations when offers are coming in. Okay. Why? Because now the seller knows what the issue is, if there's any issues with the property. So if a buyer submits an offer, remember the buyer has their due diligence to do their independent inspections and satisfy themselves with the overall condition of the property, right? And it defaults to what? 17 days. Okay. And part of the seller's disclosures, right, is to provide the seller all of the documents that we're going to now pass to the buyer, so the buyer can do their research and their independent review of all seller disclosures, and also physical inspections, which also includes, doing an appraisal, going through the motions of a loan, and ultimately releasing that as contingency, right? So what this provides is doing this ahead of time. And now if the buyer comes back, hey, we already provided you with all of these disclosures, including these investigation reports, roof, sewer, whatever the case may be. It's not required, okay? The seller doesn't have to do it, but is encouraged to do so. Especially if they haven't done anything in so many years to the property, right? You can use that as an arsenal of negotiations when the buyer now is doing their investigations, and now they're requesting some type of request of repairs, price reduction, or do the repairs in general.
I just want to give everybody notice here in the office that area 169 in Palos Verdes is in an active landslide now. And if you sell a piece of property, you better put there's an active landslide there, because if it's not in that deal and you close escrow, we won't see Simon here anymore. So I'm just saying, because
Oh, you'll see me.
it's moving. It's moving 7 to 9 inches per day. That's you. Yeah, so if you make an offer on anywhere during in the area within a mile of that, you need to disclose it and put it on your offers or put it in your disclosures.
All right, let's continue. All right, section G, G as in George, exceptions to ownership and title, okay? Most will probably leave it blank, but I just use this as an example. If there's any special easements, special liens, special CCNRs, or any pending legal actions, then you'll put that as part of the conversation. So that way, full transparency to the buyer. Hey, here's some of the issues we got going on. Because what happens is, why there's issues and delays is because the sellers fail to provide certain things regarding the property. Okay, you can use this section for that purpose.
Probate.
Probate. Yes, ma'am. Okay. All right, H as in Henry. You check this if the seller intends to include a contingency to purchase a replacement property. For example, you're in the listing appointment and they're moving out of state, right? They're selling their California home, but they're moving to Florida, right? But they say, look, Simon, in order for me to feel comfortable selling my property, I need to be comfortable that I've identified, I'm in escrow, and that I can close on a property. Because if I cannot identify and navigate a property, then therefore, I may not want to sell my property. I want the reinsurance, right? That I could buy that replacement property. All right, so I completely understand, Mr. and Mrs. Seller. There's a provision on the listing agreement that allows me to display that information to the offer coming in, that it's subject to you finding a replacement property. But, okay, in order for us to be in that position, we have a contingency, no different than a buyer contingencies. You will have this as a contingency. And the buyer may press upon us within that contingent period to either release that as a condition, or they have the right to cancel if you cannot find a replacement property, because we're not going to drag for weeks and months until you choose to find a property. So it also gives the buyer some reinsurance too, that we're not going to be on a long escrow. Okay, and the default on the seller contingency is 17 days. 17 days. Now the seller may say, look, 17 days is not enough time. I need at least 30 days. So part of your negotiations when you're going back and forth with an offer, you're going to put that the SPRP form, we're asking for 30 days instead of 17 days. Does that make sense? Yes, sir.
So what if the seller has another piece of property that hasn't been developed yet? Like they want to put a house on it. So they're not contingent on purchasing the property, but building. Would that fall under, I mean, how specific do you have to get?
Yeah, that's going to be then that particular scenario, we're probably going to ask for a longer escrow period.
Yeah.
You know, and I've seen escrows up to 9 days, 3 months.
Yeah.
Or, you know, have a conversation with the seller and says, look, I understand. But to reinsure that we take advantage of the market right now that it's hot and get you top dollars, sell the property and we'll ask for a seller in possession for an additional 30 days or longer, right? Or, you know, the seller vacates the property, goes and rents a place, hotel, Airbnb, and it's a lot easier than trying to think, okay, how do we navigate when it's new construction, right? Find that solution. That's our job. Find the solution. Because there's a solution to every matter in life. Make sense? Okay. All right, so section J, seller opts out. If you check it, what you and the seller are agreeing is that the seller does not want a lockbox or a for sale sign. Okay. If you leave it blank, it's yes. If you check it, it's no. Make sense? Some sellers don't want lockboxes. Some sellers don't want for sale signs. But the conversation you're going to have is, you know, part of my marketing is to put a lockbox and also put a sign here so we can get full exposure to the property. Make sense? Do you have any concerns regarding that? No? Okay, wonderful. So let's continue. Additional terms, section K. It's left there for that purpose. What is additional terms? Sample commission structure, marketing and advertising, showing instructions. Maybe the seller says, look, Simon, I'll give you the listing, but between this time and this time, on Mondays or Sundays, we do not want any shorts. Very specific, right? And you're going to write it down. So that way, if there is a misunderstanding, go back to the listing agreement. Well, Mr. and Mrs. Seller, this is what I wrote. This is what we agreed to. And I have it here documented. All right. Because it's so easy to be in that situation. Okay. Any questions regarding K?
Commission structure, sample commission.
Yeah, commission structures can be, you know, if I hit a certain price point, you know, the commission may change on the listing aspect of it, right? So that may change from a 3% to a different commission.
Mention
Yeah. Additional terms. All right, section 3 goes into advisories. It already defaults the broker compensation advisory, all right? It already defaults. So BCA is already, so it populates moving forward on the listing agreement that you're going to sign today and tomorrow and in the future will include the BCA form.
Oh, it'll automatically check it for you?
It's already default. So it means once you do the listing, it's going to populate the form as well. The next one is section 3B is again, if the buyer has done any additional stuff that they'd like to provide the buyer, you're going to include seller reports, any invoices for your investors or flippers, right? The new law that came in effect this month at the beginning of July, right? If you're doing investments and you've got a contractor doing work, you must provide the name of the contractor, information, and if there's any warranty regarding anything done to the property, extension of square footage, upgrading the bathrooms and kitchens, whatever the case might be, full transparency. Here's all of the information. Okay, and you can add it as part of this agreement. All right, now let's go into the real meat and potato of what the listing agreement really is. Okay, because this is really where it's going to define and put perspective and understanding of how we're going to be practicing now real estate moving forward with all of the changes happening as we speak. So as I mentioned, all commissions are not fixed by law. They're set by each individual broker, right? It's always been and will continue to be. Whatever you and the seller agreed upon. Now, obviously, and also there's a provision about management approval. If we believe that it's too low, we can also decline that listing agreement. Okay, that's per independent brokerages. Okay, so just understand that. A, B, C, and D advisory real estate commissions include all compensations that fee broker and are fully negotiable. Compensation to broker, seller agrees to pay a broker compensation for services under this agreement. And what I like about this agreement too, folks, it's full transparency. There's a lot of like, what if the seller does this? Am I entitled to a commission? Yes, there's a lot of provisions in here that really sets the tone and how we can get paid a commission. I love it. Okay, so there's benefits to this new agreement. C goes into optional additional compensation for unrepresented buyers. Remember the section that we signed on the first page of the grid? Here it is, folks. If no other broker company is involved in the sale of seller's property because buyer is not represented by a real estate agent, seller agrees to pay a broker the additional amount specified on paragraph 2C2. Simple.
If checked.
Okay, yeah, if checked. If you leave it blank,
Means you don't get
okay,
any.
well, if you leave it blank, then you cannot collect the additional commission from the seller. You will have to collect it from the buyer. That's where the buyer representation agreement comes to effect. Make sense? Okay. Compensation terms. Compensation is earned and seller shall pay broker as follows. Okay. The completion of a transaction, or this is what I like, or seller defaults. Okay, seller default. And it's very specific, folks, and I want you to be crystal clear in how you maneuver and navigate this. If during the listing period, right? Listing period, or any extension, can you ask for an extension if you know your listing is about to expire? The answer is yes, you can. There's a form for it that allows you to extend it if for whatever reason you need the time and the seller is willing to give you the time to do so, then that's where it means of the extension. Broker, any other broker, seller, or any person procures a ready, willing, and able buyer who offered to purchase the property on any price and term is accepted by the seller, provided the buyer completes the transaction or is prevented from doing so by the seller. Okay? The answer and the point is it has to be accepted by the seller. Okay? Does that mean if I have it listed for $1 million and a buyer agent submits an offer for $975 and the seller says, no, I don't want to accept it, are you entitled to compensation because it was a ready, willing, and able buyer? Is that a yes or no question? The answer is no. Okay? Yes, it's a ready, willing, and able buyer, but it was not accepted by the seller. Y'all with it, right? It has to be mutually accepted in order for this provision to fall into play. Seller provides the buyer complete the transaction or prevent it from doing so by seller. Broker is entitled to compensation whether any escrow resulting from such offer closes during or after the expiration of the listing period or extension. Okay. Now we go into that section about the continuous right to compensate. This is where it gives you the defined understanding under that paragraph 2C3. It says the following. If during the continuous period specified in paragraph 2C3 or the same period of time after any cancellation of the agreement, unless otherwise agreed, seller enters into a contract to say convey, lease, or otherwise transfer the property to anyone, prospecting buyer, or that person related entity, and there's 2 bullet points, who physically entered and was shown the property during the listing period for any extension by broker or any other broker, for whom a broker or any other broker submit to seller a signed written offer to acquire, lease, exchange, or obtain an option on the property. Broker's right to compensation pursuant to this paragraph shall only apply if prior to the expiration of this agreement. And that expiration is utilizing the form, the prospecting buyer NPV. What I said earlier, remember, always put additional continuous right of compensation. If you leave it blank, the cancellation or expirations today, even if you provide a list, unfortunately, because you didn't give yourself that time, today is the deadline. So if anyone submits an offer today on the date you expire, then you may still be entitled to a commission, but that's unlikely to happen. This is why it gives you that extra cushion, right? To allow you the time if the seller decides to put the property on the market with another broker, and that buyer comes back and says, oh gosh, the price is a lot less now, I'm going to submit an offer, then we can go after compensation. Okay. Section 3 goes if the seller interferes with the listing. And it says that if the broker prior to written consent, the property is withdrawn. Okay. What does withdraw mean?
Take it off the MLS.
You're taking it off. Seller has decided, look, I don't want to sell my property. Okay. I don't want to sell my property. We still have the rights under the leasing agreement for the remainder of that listing agreement. We withdraw it, but it also goes into the terminology that says the property is withdrawn from sale, conveyed, leased, rented, otherwise transferred, or made unmarketable by voluntary act of seller during the listing period or any extension, meaning that even if we withdraw it and now the seller goes back and tries to sell it to a family member, you know, there may be a loophole that we still may earn compensation. Okay. This is why you want to cover all bases. Make sense? Because we withdrew it, we didn't cancel it. And there's a provision that allows us to withdraw it. When we withdraw it, you still have the rights to the agreement till the end of the cancellation. So if we have a 6-month listing, 4 months in, the seller says, look, I want to take it off the market, we'll withdraw it. That says that we still have 2 more months on that listing agreement. And if the seller now sells it to someone else, we may be entitled to compensation.
even if we have that extension period, the protection clause, if it's our customer.
Remember, this is a withdrawal.
Yeah,
This
in
is not
case
a
we
cancellation or an expiration. Withdrawal. Meaning that the seller says, I don't want to sell it right now. And withdrawal can mean many variables too, folks. And withdrawal can mean is, look, we have a medical issue, we're just thinking of maybe just putting a pause, and maybe we'll explore it in a couple months. Okay, but if it's still within that listing agreement, then this provision is in effect, you still may be entitled to compensation.
But the word is changed, cancel, withdraw. What if it was my customer? And during that 120 days, I have my protection. Even if it's not canceled, if you sold somebody that I presented that customer.
I don't think you understand the difference. And I'll explain it or break it down. Cancellation, expiration is one. A withdrawal, it's two different things.
You withdraw and he sold it. My back.
That what?
If he sold it again after withdrawing.
So yeah, the thing is, within a withdrawal, if the seller goes and sells it, we may be entitled to compensation. If it cancels or expires, we may still be entitled to compensation, but that provision of continuous,
It's only for cancellation.
what's that?
It's only for cancellation, the provision of 120 days or 90 days.
That is
protection.
correct,
Only.
yes. Yes, the cancellation and expiration is only the provision of the calendar days after. The withdrawal is within the listing agreement period. Okay, good question. Additional compensation, buyer breach or seller recovers of damage. If completion of the sale is prevented by a party to the transaction other than the seller, then compensation which otherwise would have been earned under paragraph 4 shall be payable only and when the seller collects damages by suit, arbitration, settlement, otherwise, and then in the amount equal to lesser of half of the damage recovered or the compensation after first deducting title and escrow expenses of collection and suit, if any. Okay, instructions from escrow. Seller hereby assigns to broker the above compensation for seller funds and proceeds in escrow, right? If this is a transaction and there's damages, we may be entitled to some compensation from the damages that the seller incurred. Because you also lose in this, right? Because the deal did not successfully close. And now we're in a litigation, the seller won, there's compensation of the buyer's deposit. We may be able to collect some of the money for expenses, all right, as part of what the additional compensation terms. All right, so seller compensation obligations to others. There's 3 provisions to this. 1, 2, and 3 said the following: seller represents the seller has not previously entered into agreement. Okay, if the seller has, they're going to provide you. If any of these buyers buy, you're not entitled to a commission if that's the specific buyer ends up buying the property. Full transparency.
The list.
Yes. Seller warrants that the seller has no obligation to pay compensation. Seller maybe never put the property on the market, then this provision does not fall. These are for the scenarios and situations where it expires, it gets canceled, and then the seller provides this list of buyers that have seen the property or submitted offers to the property. Makes sense? Okay. Number 3 goes into if the property is sold to anyone specified on paragraph 2C for during the time seller obligated to pay a compensation. Again, it just kind of ties up to the same scenario and situation. If the seller was in a previous agreement with a previous brokerage to protect the seller from paying double commissions, they're going to provide this list of buyers, right? And that goes on both sides because you might have been the previous listing, right? Or you may be the new offer coming in. There may be some delays in process and how all that navigates, right? Because now the previous listing agent may say, well, I'm entitled to some compensation because we provided you with a list of these buyers, and this specific buyer ended up buying the property. All right, G, and it's in bold. The maximum listing period allowed by law. Okay. What that section is that it's, the listing agreements cannot be more than 24 months. Period. Only, and it does not apply if it is a corporation, LLC, or partnership. It is unlawful to record a file in the list agreement or notice, therefore, to the county recorder. I don't know why they added this provision, but what it says is you cannot go and record this at the county recorder's listing agreement. I
Well,
don't
you
know
can
why that.
renew it after 2 years, am I correct?
Yes.
You have the right to renew it.
Yes. So someone apparently probably tried to record a listing agreement at the county recorder's. As it says here, it is unlawful to record or file this listing agreement. So some agent went out to the county of Los Angeles and says, I'm gonna report this.
Yeah, he had a mask over his eyes, not over his mouth.
Yeah, interesting, but that's what it says. Section 5 goes in, again, back to the grid. I'm not gonna talk too much about it. It's pretty self-explanatory. Included, excluded, as we said, what is included, what is not included. Leased or not owned. Smart home features. Seller representation, okay, section C. Seller represents that otherwise specified in writing, seller is unaware of any notice of default recorded against the property. 2, any delinquent amount due under any loan secured by any. So it just goes into disclosing that if the seller does have or does fall in any of these scenarios, they need to let us know.
Is there gonna be a specific thing in the MLS, like if this is a standard listing, notice of default, that's gonna still exist?
I believe it's still going to exist. And if it doesn't, you're going to add it, right? Especially if it's an NOD.
Right.
Under the NOD, notice of default, we have to disclose that to the new buyer because the bank may foreclose before we can close on the deal. So the buyer needs to know that so we're protected, that we disclose that and they don't come back to buy this, okay? So seller representation. All right, so broker and seller duties, pretty self-explanatory. Obviously, as the listing agent, you have some responsibility. Broker agrees to exercise reasonable efforts and due diligence to achieve the purpose of this agreement. Unless seller gives broker written instructions to the contrary, broker is authorized but not required to 1, order reports and disclosures, including those specified in paragraph 7E as necessary, advertise, market the property by any method, okay, any method, and any medium selected by the broker, including MLS and the internet, and to the extent permitted by these media control of any information submitted to any medium, and 3, to disclose to any real estate license making an inquiry, the receipt of any offers on the property and offer price of such offers. This information was on the previous listing agreement that really says that if anyone inquires, I call Champagne as an example, ring, hey Champagne, son of Cazares with Keller Williams. Is the property still available, right? Based on the MLS, it shows active. She's gonna say yes. What it says here, and if you understand the elements, is if you have a listing agreement, you're bound by this language. Now, if the seller says do not divulge that information and you have it in writing, then you can say, I'm not privileged to provide you with that information. Just submit your offer. But based on this language, disclose to any real estate licensee making an inquiry in the receipt of any offers on the property and offering price of size. So what that means is I can ask Champagne, how many offers do you have?
5.
Okay, what's the highest offer you have? Is it above?
10,000
So-
over.
Based on this provision, you can ask that question. How many times have you had that conversation and the listing agent avoids that? Well, if you know your contract, sorry about that. If you know your contract, you can take, you understand that under paragraph 7E, it says that if any licensee, and it says licensee, meaning you as a license agent can inquire such information.
You have to give exact price and everything, or you have to give like a above and.
What does it say here? Offering price of such offers. So meaning that if she says she has 5 offers, I can ask for all of the 5 offers. Based on this language. Interesting.
So now we're gonna be committed to, what the broker, unless the seller says, do not tell anybody about my offers. If the agent, if the agent calls us and says, hey, how many offers do you have? And say I have 4 offers, well, what's your highest offer? That we just
Not
tell them.
Yeah. As long as the seller says to you, hey, Jim, I'm instructing you, you're gonna put it in writing. I don't want you to divulge how many offers you get and what is the offers you have. To anyone. That's your instruction. Now, when Simon calls and I ask, unfortunately, seller's instructions or seller's directed me not to provide that information.
So the highest and best offer below me, which I don't cooperate with, by the way. Because last time I said that to my client, he says, I gave him my highest and best offer. I'm not gonna bid against myself and give him an offer that I don't know. That I'm just gonna make an offer at 15,000 over asking price, and somebody's like 5,000 over asking price.
Yeah.
Find another property.
All right.
Is the record disclosed that word, you have to have it in writing or verbally will be acceptable?
You don't do verbals. You want to have concrete, an email, a text message,
From the seller?
something maybe on the listing agreement under additional terms. Okay, an addendum saying part of the process if anyone inquires, and it's very far and few folks that you're going to get that, right? Usually agents don't even know that it's what they're signing, that they have to divulge this information already to you. But they act like they know is like, no, I cannot provide information. And then we're trying to kind of teeter tot this. Well, is it higher than the asking price? Is it lower? Is it under? Stop.
How are we gonna know
Okay.
if you have a,
Well, you're not. But again, we have to be professionals, right?
Right.
At the end of the day. For me, I'm full transparent. You call me, because I know the listing agreement, I'm gonna say, yeah, I got 5 offers, okay? The highest offer I have is 25,000 over asking. So what am I doing? I'm trying to get the most money for my seller.
right?
Why wouldn't I want to divulge that? The buyer doesn't have to submit an offer. They don't have to, they can still submit an offer and asking. But it may not be accepted, it may not go into counter offers, but at least they know to explain to the buyer, well, we already got something over 725, you want to go for it? And maybe you should. You're not wasting time as a listing agent, and the buyer's agent is not wasting time. Yes, sir.
So the other side of that would be have offers, but they're under asking. So can my seller instruct me to say, yes, we have multiple offers, but don't tell them what they're at?
100%, yes, sir.
Okay.
Yeah, that's part of your job is to navigate this with seller. If the seller gives you specific instructions, and by all means, yeah, we have 5 offers. Can you tell me what the offers are? Unfortunately, the seller has instructed me not to. So bring your best offering. Make sense? Any other questions? Clear? Good. All right, strategy affecting delays of offers. Okay, broker compensation. This is, again, you added information to the listing agreement. There are different strategies for obtaining the best offer for sellers. Sellers advise that certain buyers may prefer not to be a competitive situation and either may not make an offer if there is instructions that all offers will be presented at a later specified time. Okay, remember the delay? The seller can receive them as they're coming, or the seller could say to you, hey, John, I know this property is going to sell quickly, but I don't want to have them as they come. I just want to get all of the offers one day and we go through all of them and then I'll make a decision which to counter, which to reject, or which to accept. That's simple. Okay.
And if there's no offers, you gotta make an addendum to it or what?
If there is no offers, then part of that provision is obviously you're gonna keep the listing active
Right.
until you get an offer. So then you may change the time frame now from, say July 30th to maybe August 1st or 5th. Yes, question.
Yeah, in there, you're explaining the seller that the buyer may request the seller to pay for buyer's broker's commission. So you were saying earlier that we are not gonna be discussing if the seller is willing to pay for buyer's commission. But in here, we can go, what about if we don't get any offers, would you be willing to pay for the buyer's commission? Based on this information. So if the seller says, you know what, if we don't get any offers, I agree to pay 2% commission, where do we put that information?
Well, and that goes back to, yeah, Rosie, thank you. And that goes back again. Remember, the listing agreement doesn't have anything about compensation to any cooperating broker, right? Under this provision is, they're going to have to submit the offer. They're going to have to also, part of your job as a listing agent is on the negotiations to get a copy of the buyer representation agreement, because the buyer will be responsible to pay you a commission, right? The buyer representation states, and it's very clear, folks, that it says that the buyer is responsible to pay you a commission. But also on the buyer representation agreement, it has specific language that if anyone other than the buyer pays you a compensation, then that offsets the responsibility for the buyer to pay you, the agent, compensation. So how you're going to navigate this is very, very simple. And I'm not going to try to confuse you, but this is how it's going to work, right? You see a property on the MLS, you're not going to see no compensation right come August 17. You can't even have conversations about commissions with the listing agent because that falls under the NAR settlement. You're just going to submit the offer, the agency disclosure, possible representation agreement, wire fraud, and proof of funds, all of the information, including your purchase agreement. You're going to have G3 on the purchase agreement check, right? That check means that you have a buyer representation agreement with this buyer. Okay, that if it's going to stay as a permanent or it's going to still be an option, I'm not 100% sure yet. But let's say that it already defaults, then it automatically, when you do an offer, it's also going to include the buyer representation agreement. Now, remember, when talking real estate, you're probably going to have the agreement signed even before an offer is made, right? So, but if it's on the purchase agreement, if G3 is signed, you're letting the listing agent know that you have buyer representation agreement, right? So now when I'm negotiating with you, I'm going to ask for a copy of that. The seller can ask for a copy of your buyer representation agreement because I want to know what the commission that the buyer is going to pay you. Okay. Now, part of the process is, because I know everyone is wondering, well, how do we collect commission if the seller is willing to pay some type of compensation? Where that's where the BCA form comes into play, but also the SRPP form. SRPP form is the form that you're going to utilize for the purpose of asking the seller to pay your compensation. And on that SRPP form, it has the section of compensation that you're asking the seller to pay. Now, when I see the buyer representation agreement and I see 2.5%, okay, and the seller, after seeing your offer, says, look, I'm okay giving some concessions to the buyer's agent, then they're going to put that they're willing to pay you 2.5%. Now, if your compensation is less or more, okay, per the new regulations is, let's say that you have a buyer representation agreement for 2%, and you submit your buyer representation, and the seller, if the seller is in agreements to, you submit an offer for 2.5%, which is more than 2%, and the seller agrees to pay that 2.5%, you're going to need to change the buyer representation agreement to align, because you cannot exceed the amount that the seller is willing to pay. Okay? It has to be in alignment. So if you're asking 2 and the seller's giving you 2.5, you're not going to be able to collect that 0.5% for the new rules and regulations. You're going to have to modify your buyer representation agreement to the agreed upon 2.5% or whatever that amount is. So in theory, my suggestion is know how to sell your value with the buyer with the goal of negotiating, your compensation with the listing side and the seller, right? When you're having the conversation with the buyer. And therefore, if it is, say, 3% that the buyer is responsible, and now you negotiate and you throw in a 3% on the SRPP, and the seller comes back and says, no, I'm not going to give you 3%, but I'm willing to give you 2.5%, right? That means that the buyer would not be responsible to pay you the addition. Okay? So if that's the case, you can look at it from 2 different perspectives. One, you can ask the buyer to bring the additional 0.5% into escrow to pay you that compensation, and then the seller will pay the remainder 2.5%. Or you can also say, look, I'm already collecting compensation from the listing side. I'm going to go ahead and not collect anything from you. That's the beauty that you have that power. Or you have the initial to say, yeah, I'm still entitled to your compensation.
You written that thing? Just
Say again?
that deal that you just made, it's gonna be written somewhere?
Everything you do has to be in writing. Yes, Lily.
At what point do you find out whether or not the seller's giving compensation? And at what point do you submit your agreement with the buyer to the seller?
On the submission of the offer. When you submit the offer, you're going to submit the compensation, the SRPP form. You're going to submit it with your offer, asking the seller to pay compensation. So when you submit it, you're going to submit it.
Can I interject for a moment?
Sure.
This is what I'm intending to do, and I think Rosie and then probably a lot of us have the same concern that we want to have a discussion with our sellers at the time of our listing, okay, about compensation to buyers agents as the concession and sellers willing to. And so as an example, here is what I'm going to be including. I have a listing appointment this afternoon, and here is what I'm going to be drafting under 3K under the additional terms. Okay. And here's how it's going to read. Upon receipt of an acceptable offer, seller additionally agrees to pay 2.5% of agreed upon sales price as a concession to the buyer's obligation to pay for buyer's obligation to pay compensation of buyer's agent to buyer's agent. So it really has no meat in the listing agreement, as opposed to what it does is it has the discussion and sets forth the seller's intent. Okay, but it obligates the seller contractually at that moment of taking the listing, okay, no further than the terms set forth, set forth in C1 and C2. But at least then the dialogue and the discussion now is able to be had, and at least there is some written memorandum to memorialize the discussion and the seller's intent.
Got it. And that's on the what form?
And I drafted that as additional language that would be drafted into K under additional terms.
can I interject real quick?
Yeah, go for it, Brandon. Thank you, Steve. Go for it, Brandon.
So Steve, what I would have these conversations, Simon, so I was being careful, but
Brandon, you're coming delayed. I don't know if it's your mic.
Somehow it sounds like you're stuttering.
You better get T-Mobile.
there's no reason why, to Rosie's point, or anyone's point, you can't, yeah, be done. Go ahead without me, I'm in a bad spot.
Okay. All right. Once you're in a good spot, Brandon, come back on the chat, please.
Simon, this is Stefan. Can you hear me?
Stefan, yes, I can hear you.
Hey, I think that there's a legal reason that there is no reference to the buyer's agent's commission in the listing agreement. So the entire purpose of the lawsuit was to uncouple the buyer's agent's commission from the seller's obligation. And I think simply we're going to get paid representing buyers in one of two ways. We're going to write it into the offer when we write the buyer's RPA, or we're going to receive it from the buyer as part of the buyer's representation agreement. And when we have our listing presentation, and I understand Steve's point, I was thinking about something similar as a dialogue, and it was something to the effect of Mr. and Mrs. Seller, previously, the buyer's agent was compensated by the seller as part of the listing agreement. Now that's negotiable. So my listing fee is 3%, but I would encourage you to set aside an additional 2% in case we have to use that as part of our negotiation. If we don't have to use it as part of our negotiation, then kudos to you, you keep that 2%. If we do have to use it as part of our negotiation, you're already in the mindset of knowing how to do that or wanting to do that. So I think Steve and I are saying the same thing. Steve, I see you nodding. I just would be leery of documenting it because I think the entire purpose is that it is not part of the contract.
Got it. Yeah, I mean, you're probably correct based on this. And right, if by having it potentially, I could be subject to, slapping of the wrist. No doubt about it.
Yeah.
Simon, I don't know if you saw in the chat, but is this not something that new gap addendum that you created would address?
No.
No. That is totally different. That gap addendum is right now, well, yes and no. So this, if we're just talking right now, let's just say that it's already August 17th, that gap addendum will not be in effect anymore. What we're talking about moving forward is the standard practice of how we're going to maneuver conversations around commissions. We cannot be having conversations around commission. The only conversation you're going to be having is you and the seller, and that's it.
About the listing agent's commission only, right?
Right.
Only, yes. Nothing about conversations around what the buyer agent is going to be paid. And I want to be crystal clear. They can submit a request as part of the process. And now it's going to be a negotiating tool if the seller wants to or not. So I don't want any of you to be confused in how we're having this conversation, because even CRMOS, if you put anything in relations to compensation to the buyer, they're going to be policing this and you're going to be in violation. Okay, be very careful. This is why it all started, and this is the reason we're now going through the trenches of these new agreements, because seller is not obligated to pay commissions to any buyer agent. Moving forward, yes.
But don't I have an obligation to my seller to educate them about the fact that this should be expected?
Yes, and that's where all these additional advisories will come into play. and how you're going to explain the do's and don'ts of how the process of navigating compensation. The buyer can submit a request, because remember, moving forward, the conversation is have that mindset and understanding. When you go on a listing appointment, right? A listing appointment, the whole purpose is to get the listing, and you already know what the compensation is going to be. Now, when you're having a conversation with the buyer, having the mindset that the buyer is going to be responsible to pay compensation to you moving forward. Okay. Now, the question here is, can the buyer ask the seller? Yes, the buyer can ask the seller to help offset the cost of his obligation, his or hers, or their obligation of their responsibility to pay me a compensation or commission. That's all it means. Okay. Are we clear? Okay. All right, let's continue. Saban, thank you very much. Steve, thank you. And if Brandon jumps on the call back, we'll open it up. Any other questions? Ali, as well. Again, the gap addendum is right now, because it's still not in full effect. Okay, so yes and no. You can have the conversations right now till the day of August 17 to add this additional addendum to offer. But what we're talking about is let's just say that it's August 17 now. This is going to be the new norm. And we're navigating and how the listing agreement plays a big factor, that there's nothing that says about compensating the buyer's agent. Okay. All right, let's move forward. So section 2, seller instructs broker to present offers. So again, as part of the grid, broker agrees to present all offers received by seller property and present it to the seller as soon as possible, unless seller gives written consent, right? And that's that section. If they say, hey, I don't want to receive them as they come, we'll do it 5 days, 10 days from now. Seller instructs broker not to present offers, and that's the paragraph. Buyer supplement offer letters. I'm not going to go too much into details on it. It's pretty much the letters that we call love letters. Okay. Seller's good faith. This is a new added provision. Seller agrees to consider offers presented by broker and to act in good faith to accomplish the sale of the property by, among other things, making the property available for showing at reasonable time and subject to paragraph 2C4. Referring to broker all inquiries of any property interest in the property. Seller is responsible for determining at what price to list and sell the property, right? If I go in the motions of a listing presentation, part of my arsenal of tools, right, is I'm going to do a comparable market analysis, right? CMA, apples to apples. I'm going to compare properties that are similar in characteristics to the property, right? Square footage, how many bedrooms, the year was built, what upgrades, what's the size of the lot, so on and so forth. And I'm going to look at other properties within half a mile to a mile radius of the subject property, right? I'm going to present that to the seller based on my analysis of what we have in front of me, Mr. and Mrs. Seller. My opinion around where we need to be is this. Seller doesn't have to agree to those terms, right? That's what this provision says, that it's the seller's discretion of what they want to put their property on the market for. Now, with that, does that mean you have to take an unrealistic listing price? No. So if the seller believes their home is worth $10 million, that's not being realistic, right? So you have to make that decision if you want to put all the efforts and try to sell this property, or if they're going to decide to concrete market trends of what's happening in their neighborhood. Because the goal is we're not in the babysitting industry, we're here to sell homes, right? So in essence, they look to our expertise and how we maneuver and help the seller sell their home.
Just asking, you want me to bring a folding chair to your house or a rocking chair?
All right, investigation and reports, again, under that provision. That we talked about, if the seller wants to be any pre-inspections done on the property, undisclosed conditions, incomplete or incorrect information. Seller further agrees To identify, defend, and hold the broker harmless from any claims, disputes, just a self disclaimer. Broker deposit is authorized to accept and hold sellers' behalf of any deposit to be applied towards purchase price. This is something that I don't know why they added this language about deposits. Typically, give it to escrow, right? Usually the standard practice, it's always the deposits go to escrow. 9 goes into agency relationship and all the disclosures, possible representation. I'm not going to go into it. Here's that language of unrepresented buyer as clearly stated on the grid. If a buyer is interested in viewing seller's property, is not already represented by a real estate broker, and such buyer refuses to be represented by a broker, seller, authorized broker to obtain a signed document from such buyer refusing representation by broker. Broker shall provide such buyer at earliest practical time a disclosure of non-representation, such as buyer's non-agency form B&A, open house visitor non-agency disclosure, or the the OHNA form. Okay.
Well, they have a new form for it now.
There's 3 different forms now that specifies the understanding if a buyer is unrepresented. Does that mean that if a buyer goes into your open house, that is considered a non-represented buyer? It doesn't mean they're going to buy the property or submit an offer, but part of the process in full transparency, folks, we have to still provide some type of documentation. No difference than what we saw back in early 2020, right? The P forms, right?
So what if he says, I don't want to be represented at all? You have to give him that form and sign.
Yeah, so let's say you're doing an open house and it's not going to be like a registry. So that registry, I believe I showed you yesterday, no? It's a form that signs saying, hey, I just want to see the property. I don't want any representation. I just, I'm a neighbor, as an example.
Is that form?
Then that form,
Good forms?
yes, the forms are available right now through your zip forms. Confirmation, just the relationship you have. Termination of agency, seller acknowledges, agrees that the representation duties of an agency relationship with the broker terminates at the expiration of the agreement. It's just pretty self-explanatory. You have a beginning date and an expiration date. That expiration terminates our relationship. Section 10 goes into security insurance, showing audios and videos. That the agent is not responsible for any damage and occurs. If the seller has videos and all that stuff, that we're mindful of all that. Photography and internet advertisement, I'm not going to go too much into it. Lockbox, pretty self-explanatory. We talked about it. Yes, seller does not. Sign on the property, equal housing opportunity, attorney fees, and here it is, section 16, folks, about management approval. If an associate licensed in a broker office, salesperson or broker associate enters into an agreement, broker or manager has the right to cancel this agreement within 5 days after its execution. If we find something that is not in alignment, we have the right to not take this listing. Okay. Successor assignees, this agreement shall be binding upon seller and seller successor and assignee. Basically, the original sellers have passed away. There's a successor to the trust, then they have the right to sign on behalf. Mediation, arbitration, additional terms, pretty self-explanatory. Obviously, before it escalates to a potential lawsuit, we want to mediate it. And if we cannot come to an agreement during the mediation, then we can escalate it into an arbitration. 19 goes into the entire agreement, basically everything that's on there. Seller, agents are in agreement. Otherwise, you have to modify whatever terms and understanding between you and your sellers. And then obviously the authority signers, obviously, if they are not the authorized person, then you have an invalid listing agreement. If it is an entity, then they would check the entity box, and then the RCSD form will populate for your investors. that are selling investment properties. It may be a corporation, so there has to be someone on behalf of the corporation that will sign, CEO, the president, the managing member. They're the ones that you're gonna include the representative capacity. And then this language is in there for that purpose. Seller signatures, confirming, broker signature. If there's more than one agent, then you're gonna include the AA form. Here, that means two agents, same brokerage. If you have two agents from two separate brokerage, then you would check the ABA form. That's two different brokerages, two agents working for the sellers, which is acceptable. Okay, question?
They can no longer sign with the entity name, the LLC name, like John Doe LLC. Now they have to put a person responsible.
Well, John Doe LLC, it's an entity. They're not a person that signs.
Right.
We need the person that's authorized on behalf of John Doe LLC to sign. So we need to know what that title and their signature. So you're not gonna sign John Doe LLC. That's not your entity. Your entity is you. You're gonna sign on behalf of the entity. Make sense? Okay. Real quick, the multiple listing service addendum, this is also included as the new agreement. And it goes into the understanding and how all this has been aligned with the agreement. I know we're going a little over our time and I apologize, but I think this is core information that we all need to. And the best practice is get the contracts, read them, read them, read them. If you have any questions, by all means, please reach out to us. We're here to help. So what is the multiple service? You know, pretty self-explanatory. You know, the importance of using the MLS. What information is provided to the MLS before or after the sale? What is broker MLS? Pretty self-explanatory. Benefits of using, you know, the MLS, the pros and cons. You know, some sellers decide they don't want to put it on the MLS. They'll take it off the MLS. And that's okay as long as we have an exclusion, seller instructing us not to put it on the MLS, then it doesn't have to go on to the MLS. Not listed property in a local MLS, but again, it's pretty self-explanatory. Coming soon status impacts the marketing days on market. Sellers advised to discuss with broker the meaning of coming soon. Does everyone know what coming soon means? Pretty much all of us should be aware. Coming soon allows 21 days from the time you put it as a coming soon. Can you start marketing the property as a coming soon? The answer is yes, you can. But remember, it's not until full active is when typically you can start receiving offers. It's just really showcasing. It's just really showcasing that a property is in the midst of coming into the market live. Seller's instructions. This is the second seller instruct broker to market the property to the public on the beginning date, and then falls into the clear cooperation applies or doesn't apply. So all of the language that was used to be incorporated into the listing agreement has been now taken out and now more into its separate owned advisory form. Have a seller sign, and that's pretty much it. Any questions?
That's all.
Here's the broker advisory form, folks. This is again that explains and illustrates how listing agreement compensation is fully negotiable, optional compensation to the buyer unrepresentative. Broker may present both buyer and seller as a dual agency. Buyer represents compensation is fully, again, negotiable if it's a buyer, right? This is the seller, and this is the buyer. So again, part of the process on the submission of an offer and the listing, now it's going to include the BCA form, okay? This is going to be now the standard practice, and it goes in again, if the buyer pays the compensation pursuant to the buyer representation agreement, then you're going to utilize the form BC form as illustrated. Seller pays the compensation. Here it is. Buyer negotiates for seller to compensate buyers. Okay, so here's the information, and I think with Stefan, Stephen, and Rosie, and how do we maneuver this. A buyer may make a conditional offer to the seller by including a term in the purchase offer, asking the seller to pay the buyer broker if the buyer has already agreed to pay their own broker pursuant to a buyer representation agreement. So there's the key, folks. There has to be a buyer representation agreement to be in alignment to ask for compensation. It says it very clear here. Okay, request will become one term among many that the seller may accept, reject, or negotiate by way of a counteroffer. So when someone, a buyer submits an offer, they're going to submit the SRPBB form, right, or PP form. That's going to ask the seller for compensation. The seller and the listing agent can use that as negotiation and say, no, we're not going to pay you 2.5%. We're going to pay you 2.25% instead. Once that is accepted, then that's going to transition now to escrow, and then escrow is going to know what the compensation is. If the buyer is going to pay compensation, then escrow needs to know that, because there's going to be additional funds that the buyer will need to make sure that the deal closes. Closing costs, down payment, plus additional funds to pay you the compensation. Okay. Changes in practice related to seller broker offer compensation. Again, the language regarding the MLS that come August 17th, the VAC section will be removed from the MLS. Okay, and that pretty much is everything. Any final thoughts or questions that you may have? All right.
I have a question, Simon.
Yes.
How do we get this recording?
You're going to be able to get this recording with the respective offices. I know, or send me an email and I'll have that this video recorded sent to you as well. So if anyone wants a copy, it should be sent out to everyone. But if you want a copy of the recorded, just let us know. We'll send it.
Simon, I should be sent out to everyone, and I know Kim, I think, is going to post it once you send it to the YouTube page.
Yeah. Yeah. That's going to be provided, folks. All right. Thanks, everyone. Appreciate it.
Thank you.
Thank you, Simon.
Thank you.
Thank you.
Thank you.
Simon.
So we should. They have the, like, kind of talking about.